As I mentioned before, I have the transcript of Alex Murdaugh's federal sentencing hearing. As most of you probably already know, federal hearings cannot be recorded in any way. The transcripts themselves have to be purchased. So although we already know the outcome of this, there are some interesting details from this hearing, a few of them previously not well known, if known at all. I had one of my dear friends help me in the reading, and it's just simply the reading of the transcript without any additional commentary. The sentencing portion of it is a little bit technical, a little bit long, but there's more information after that. So you might want to hold on until the end, or even fast forward through the technical sentencing portion. Without further ado, it's myself and my friend, S.M. Townsend.
Good morning. Please be seated. Miss Limehouse, are you ready to call your next case?
I am, Your Honor. May it please the Court. We're here in the matter of the United States v. Richard Alexander Murdaugh. Criminal docket number 923396. Mr. Murdaugh is here today, represented by his attorneys, Mr. Jim Griffin and Phil Barber, and we're here for the purposes of sentencing.
Very good. Mr. Griffin, good morning, sir. Good morning, Your Honor. I want to confirm you've had a chance to review the pre-sentence report.
We have.
And you've had a chance to consult with your client concerning the report?
Absolutely.
Could we swear to the defendant, please?
Please stand and raise your right hand.
Mr. Murdaugh, good morning, sir.
Good morning, sir.
I want to confirm you've had a chance to review the pre-sentence report.
Yes, sir.
And you've had a chance to consult with your attorneys concerning that report.
Yes, sir, I have.
Very good. Okay. Let me take up a couple matters before we go through the guidelines. Mr. Murdaugh, you can be seated. I received a motion from the government to hold the defendant in breach of a plea agreement. Ms. Limehouse, my understanding is that the parties have reached an agreement that the government is relieved of its obligation to make a recommendation under the plea agreement. Is that correct?
That's my understanding, Your Honor.
Is that correct, Mr. Griffin?
That's correct, Your Honor.
In light of that, I rule that the motion is moot. Docket number 65 is denied as moot. Next, are there any objections to the pre-sentence report? Yes?
Just a docketing matter, Your Honor. There's also a motion to compel with respect to the polygraph charts. I want to make sure that that is also moot in light of the agreement.
When you say yes, Mr. Griffin, what's your response? I had confirmed the sealing. We will withdraw the motion. We filed a motion late Friday asking for the underlying data of the polygraph. In light of the events of an agreement, we will withdraw that motion.
Very good. That motion is withdrawn. Okay. Now we have objections. First, there was an objection, Mr. Griffin, to the loss amount.
Yes, Your Honor. We're also withdrawing that objection because, as the probation officer accurately pointed out, there's a lesser dollar amount for the money laundering, and it equates to the same sentence as the loss amount for the...
Correct, it does.
So, it's moot.
Very good. So you're withdrawing the first objection?
Yes, Your Honor.
Okay. Then there was an objection concerning the criminal history points. I'm glad to hear you on that.
Yeah, that's correct, Your Honor. Under the criminal history calculation of the guidelines, the probation office has added 3 points, I believe, for Mr. Murdaugh's plea to a state tax evasion charge which carries 5 years. That plea took place at the same time as the other 22 some-odd counts he pled guilty to in state court.
Was it the same victim?
Well, it was a tax case, and the victim would be, the South Carolina Department of Revenue for the tax evasion.
Was the crime the same? That is, tax evasion the same as these other crimes?
So, Your Honor, the question under the guidelines is it relevant conduct, and the money that he evaded paying tax on are the proceeds of the underlying criminal conduct. And you can look at it in 2 ways, Your Honor. One is, if it was a crime committed to cover up the offense because he'd gone to an accountant and said, I have been stealing $8 to $10 million, I need to pay taxes on it, then that would have uncovered his criminal conviction, his criminal conduct. The other piece, Your Honor, under the guidelines, the testing of whether it groups, we've cited case law in our memorandum about grouping where it involves continuous course of conduct, which that is the case here. And ironically, Your Honor, if the government had charged Mr. Murdaugh with tax evasion, which they very well could have, because he didn't file any federal taxes on this money either, then he would be looking at 3 points less under the guidelines. And that's the irony of the situation. So that's...
There are many ironies in this case, Mr. Griffin.
Excuse me?
There are many ironies in this case. Miss Limehouse, the government's view?
Yes, Your Honor. The defendant relies on the grouping rules, which of course only apply when we're talking about federal charges in the same charging document and someone being held accountable for those in the same sentencing. The relevant inquiry in terms of relevant conduct that this court is to determine is whether these are severable, distinct offenses, not whether they would be grouped, because there's just no way to group a state tax conviction with these federal.
In fact, there would be no sanction at all if we did what the defendant is asking us to do.
Exactly. And I think that's the ultimate sort of policy.
That's the tally point. The Third Circuit case makes that point.
Exactly. But the court's determination should really be based on whether there are different charging documents, different sovereigns, different victims. And of course, we're talking about a state tax conviction charged by a different sovereign in a different charging document that involves completely separate and distinct victims from the victims that...
And a different criminal scheme.
Exactly. And so to allow him to not be held accountable in a criminal history calculation would basically allow this all to be washed away to Mr. Murdaugh's benefit and would really result in a windfall that the guidelines don't contemplate. And rather than him getting a benefit, had he been charged with the federal tax violations, he actually would have had a 2-point enhancement under 2T1.1, which doesn't apply here. There's no mention of the conduct that led to the state tax violation in the relevant conduct portion of the PSR. There's no mention of this conviction whatsoever except in his criminal history calculation. And the only way this court can hold him accountable for that conduct is in a criminal history analysis. And so we think to not impose the 3 prior history points would result in a windfall to the defendant.
Well, I've read the case law on this. There is some divided authority, though I think the government does a very good job in its brief explaining how those are actually distinguishable, the cases that would allow the grouping. And I think the pre-sentence report is exactly accurate as to the way to handle the state tax. It was appropriate to be a separate 3-point criminal offense. The majority view is plainly in that direction. The Fourth Circuit's view is in that direction. And I overrule that objection. Are there further objections from the defendant?
No, Your Honor.
Any objections to the pre-sentence report from the government?
None from the government, Your Honor.
Okay. And before I announce the guidelines, could you address, Mrs. Limehouse, the issue of restitution, which I believe the parties have reached stipulation on?
Yes, Your Honor. We have submitted a restitution chart to the court and the probation office. Of course, the probation office is better at math than I am, and we're off by 10 cents. So we have amended that slightly with our own scrivener's error, and we will submit a revised one. But I'll submit this one with our 10-cent error just so the court can see. And what it contemplates is a total restitution to the law firm of $4,544,730.15. There are 2 restitution orders that affect the restitution to the law firm that Your Honor has previously imposed with Russell Lafitte and Corey Fleming, and so we would incorporate those judgments as joint and several, with a portion of those restitution amounts outlined in the chart specifically, Your Honor. With respect to Palmetto State Bank, the total is $329,913.27, and that's joint and several with Mr. Russell Lafitte. To Miss Pamela Pinckney, the total is $13,088.46, and that's joint and several with Mr. Corey Fleming. And then the insurer, who indemnified the law firm with respect to the Satterfield loss, will receive $3,875,000, and will submit the information with respect to that insurer after this hearing. So the total restitution amount is $8,762,731.88, and it's my understanding that the defendant is not objecting to that restitution at this point.
Is that correct, Mr. Griffin?
That's correct, Your Honor.
Very good. I do find that the parties have stipulated to the restitution amount. Let me announce the guidelines. And I take it the government has no objections to the pre-sentence report, correct?
That's correct, Your Honor.
Very good. Let me announce the guidelines then. The total offense level is 34. The criminal history category is 4. The guideline range is 210 to 262 months. Supervised release as to counts 1 through 4 and 8, 2 to 5 years. Supervised release as to counts 5 through 7 and 9 through 22, 1 to 3 years. Special assessment, $2,200. Restitution, $8,762,731.88. I'll be glad to hear from the defense regarding sentencing.
Yes, Your Honor. There are a couple of issues. One, under the sentencing guidelines, it requires that this sentence that the court is about to impose run concurrently with the undischarged state court sentence.
I intend to do that.
Thank you. And it also requires,
As to relevant conduct.
yes.
Okay, I do that. The guidelines so provide that.
Yes, sir. And also provide that he be given credit for the time he's currently serving for that relevant conduct.
Service credit is something the Bureau of Prisons does, and I don't make that determination, but I'll see if there's ever an issue that would be taken up with the Bureau of Prisons. But the normal practice, of course, is to do that.
Right. Thank you, Your Honor. And he did get a sentence of 27 years in state court. I think he started serving that. And he gets credit in state court from July of 2022 when he was first indicted on those charges. His release date, just for the financial crimes, is calculated, I think, at 2045, or 22 years from now. And of course, he is serving 2 life sentences for murder, and he has active appeals on those murder convictions. We don't know what the ultimate outcome will be, but he's here today to be sentenced before Your Honor on essentially the same conduct that he'd already pled guilty to in state court, and already been indicted for in state court. And frankly, it would appear that where we are in this courtroom is a result of a turf war between the Attorney General of South Carolina and the U.S. Attorney of South Carolina.
I take it as a different view. They're separate sovereigns, and they both wish to make a statement regarding the conduct of the defendant, which he has admitted to, and each, as sovereigns, has a right to do that.
I understand that, Your Honor, and they absolutely do, and there's no double jeopardy claim, and we've not made one because of that exact point. And the guidelines do, Your Honor, recognize taking into account that they run concurrently, and so we appreciate that. His sentencing guideline range currently is 210 to 262 months.
You're aware I've given notice that I'm going to consider an upward variance from those guidelines.
You certainly did, and we are aware, and Mr. Murdaugh is aware of that. Your Honor, just as happenstance would have it, I think Friday there was an article in the New York Times about recent high-profile sentences, because Sam Bankman-Fried was sentenced in New York after a trial involving an $8 billion cryptocurrency scam, and he received 25 years, Your Honor. And that article in the New York Times pointed out that Jeffrey Skilling, the head of Enron, he originally received a 24-year sentence, and that was reduced to 12 years. Most recently, Your Honor will remember Elizabeth Holmes, who was a CEO and chairman of Theranos. That's the blood testing company that was totally fraudulent. She received, after her trial, an 11-year sentence. And so there's significant amounts of losses that are much greater than the $8 and $10 million that Mr. Murdaugh did. Now, I'm not minimizing his conduct.
Mr. Griffin, you left off a case.
Excuse me?
You left off a case.
Bernie Madoff.
You've got it.
Bernie Madoff got 150 years, but he was in his 70s and he served 12 years before he died.
I believe Judge Chin, in sentencing him, talked about the long-standing criminal activity, many victims taking a huge human toll, which felt pretty analogous to our case.
Yes, Your Honor. Mr. Madoff was in his 70s and he served 12 years. Mr. Murdaugh is 55 years old. He's got 20-some-odd years left to serve, not even considering the murder convictions. And the earliest he could be released is 75 years old. And, Your Honor, the guidelines do call for a sentence range of 210 to the 262 months. He's accepted responsibility for his financial crimes from the moment he was confronted by the law firm. He has never denied it. He testified fully at the murder case about his financial crimes.
But he committed 15 years of fraudulent conduct, 27 victims, I believe. He stole from 27 clients, some of the most needy, vulnerable human beings. One was a paraplegic. They were motherless children. They were widowers. I mean, I've heard a lot of this through these multiple cases. I've seen the disgrace that he's brought, not just to himself, but to his law firm, to his county, to his state, the judicial system nationally. Those are all factors to be considered.
Yes, Your Honor, and I'm not defending the conduct, but
I don't hear you doing that.
I'm just putting it into perspective. I will say there was another case with a very prominent lawyer in the mid-state of South Carolina, and that lawyer would take money from his clients that they already had from retirement or whatever and put it in his trust account and steal it. Mr. Murdaugh, as egregious and disgusting as his conduct was, he intercepted money before these clients ever saw it. And so, until all this came to light, they were unaware that they had been victimized. And I will say,
that's a distinction without a difference.
It is, but to his law firm's credit, they stepped up and have made as many people whole as they could. And so, the victims, as you read here for restitution, are principally the law firm's insurance company, Palmetto State Bank, other third parties. And so we are grateful.
But they had to step in and pay for his crimes.
They did, and
that's the way the system works. People who have to suffer a loss, but for the law firm and their carrier, the Palmetto State Bank, these victims would have been financially devastated.
Without a doubt. And, Your Honor, I'm just pointing out that he was in a position. He abused that position, but those around him had the wherewithal and the capacity to make whole his victims. and we're appreciative of that. And so, Your Honor, we would request a sentence within the guidelines to run concurrent with his undischarged time of state sentence for the financial crimes, as well as his murder convictions. And Mr. Murdaugh would briefly like to address the court.
Yes, I'll be glad to hear from him. Mr. Murdaugh?
All right. Your Honor, thank you for the opportunity to speak with you. I'm going to try to be brief.
Take as much time as you wish, sir.
And think about this. I understand that, Judge. Just a couple things that I want to say. I do appreciate the opportunity to speak with you. And I want to reiterate to the victims that are here the things that I told them when I had the opportunity to speak with them individually in Beaufort, that I am filled with sorrow and I am filled with guilt over the things that I did to these people that I care about. I care about all of them. I love many of them, and I also want to remind them that should they decide that they would like to communicate with me, and I told them this in Beaufort, for any reason, be it to get more details, be it more closely inspect my sincerity, for any reason, I invite them to do that, and I welcome the opportunity to communicate with them in whatever manner they choose. Judge, I know there's not enough time, and I don't possess a sufficient vocabulary to adequately portray to you in words the magnitude of how I feel about the things that I did, as you pointed out, for a long period of time. I mean, I literally am filled with sorrow, and I am filled with guilt over the things that I did to people that I care about so much. And I understand that the natural reaction to what I just said is probably, is he sorry for what he did, or is he sorry that he got caught? And that would be a natural reaction. And I assure you, and I assure every victim that I hurt, that I am sorry for the things that I did. Many sessions, while I was in rehab with a very diligent counselor therapist, led me to the realization, recognition, whatever you want to say, understanding, that one of the reasons why my addiction grew to the extremes that it did was because I was using opiates to hide from the things that I was doing to people that I care about. I guess trying to numb myself in the knowledge of knowing what I was doing and had been doing. When all this first happened, and I had so much guilt and so much sorrow, so much shame, so much embarrassment, so much humiliation, there was also a sense of relief that crept in. And that relief being that it was over, that no more having to hide this secret life, having to hide this lie. That's what it is, hide this lie. And Judge, I know that I hurt and I left a lot of damage, a lot of wreckage, a lot of, I guess, overall havoc in my wake. I know that. And I acknowledge that I became that which I most despise, a hypocrite. And I know that. I know that I hurt, humiliated, and otherwise let down so many people, as you pointed out. The entire bar, which I was so proud to be a member of, and still with so many smart, compassionate, capable, honest people. And I understand the damage that I have done there. So many friends that I felt privileged to have, every one. My law firm, my partners, who I love and who are now my victims, my family, my son, and the victims of all the crimes that I'm pleading guilty to. And as I've said, all of whom I care about, and many whom I love. Judge, a little bit ago, I referenced my addiction. As I stand here today, I am 937 days clean, and I'm very proud of that fact. I do believe that my addiction contributed to me doing some of the things that I did. And, Judge Gergel, I hope with every cell of my existence, I hope that I would not have done the things that I did had I not been addicted to opiates. And while I hope that, Judge, I also know for a fact that I knew what I was doing was wrong. I knew better. I was raised better. I was surrounded by people who lived better. And I have spent so much time thinking about why I could do these things that I knew were wrong to people that I cared about and loved. And while I was doing them, I was ashamed of myself for doing them. Yet, I continued to do them. And I can't reconcile that. I can't. I make myself think about it every single day. At some point, I make myself think about it every single day. And I make myself think about the victims who I hurt every single day. By no means do I have all the answers. I probably have very few answers, but I do have a full, wholehearted commitment to continuing to try to get answers and trying to do things to improve myself. And Judge, I'm going to wrap this up. I hope I haven't spoken too long, but I do want you to know, and I do want all of the victims to know, I am filled with sorrow. I am filled with remorse. I am filled with guilt. And I also spend a lot of time trying to think about how in the world I might ever make it up for the things that I've done. And also, Judge, lastly, I am very committed to trying to be a better person. I appreciate the opportunity to speak with you. If you have any questions, I'll be glad to answer them.
Thank you, sir. Mr. Griffin, anything further from the defense?
No, Your Honor.
From the government, Ms. Limehouse?
Thank you, Your Honor. May it please the court. As the court is aware, all the parties have agreed that we are no longer bound by our obligations of the plea agreement, and we had full intention to come in here and argue that the court impose a consecutive sentence. Based on what the court has previewed for the government, that it intends to impose a concurrent sentence, we're going to tailor our arguments accordingly. Before I go to the victims, whose voices are most important for Your Honor to hear today, I want to briefly address the nature and circumstances of the offense, and then I'll address some of the arguments that Mr. Griffin made with respect to the federal interest here and why we've held Mr. Murdaugh accountable for the federal financial crimes. We've outlined, and Your Honor is very familiar with the nature and circumstances of these offenses, and we've outlined them in our sentencing memorandum. I think it's important to note the complexity of Mr. Murdaugh's schemes. We highlighted the 6 different ways over the 15 years that he executed his schemes, the co-conspirators that he recruited and convinced.
Seduced.
Seduced, sure.
The siren song of affluence, right?
That's right.
Bought off people. You know, I tried Mr. Lafitte and I sentenced Mr. Fleming. I'm convinced both of them were seduced into this by the promises and delivery of large amounts of money. Mr. Murdaugh was a skilled groomer of his compatriots. And you know, to the statements about addiction and impairment, no truly impaired person could pull off these complex transactions. They are very complicated. It took me a while to just examine several of them. And using his undoubtable charm and charisma, he persuaded all kinds of people to do things it should not have done, and in furtherance of his pursuit of countless amounts of cash. You know, one of the things that is most troubling is that the victims were amongst some of the most vulnerable people we could imagine. As I mentioned earlier, there was a paraplegic, there were motherless children, there were widowers, there were people whose lives had been turned upside down by collision or a wreck or some other tragic event, and they placed all their problems and all their hopes in Mr. Murdaugh. And it's from those people he abused and stole. It is a difficult set of actions to understand.
We agree completely, Your Honor. And when we look at sort of the total number of victims we're looking at, like you recognize more than 25 victims. And that's just those individuals. That, of course, doesn't account for their countless family members and loved ones who have been impacted by his crimes and continue to be impacted daily by having to relive some of their most difficult moments. And so you really can't overstate the nature and circumstances of these offenses. But I do want to highlight what we've highlighted in our sentencing memorandum with respect to victims who otherwise have not been publicly identified and do not wish to be publicly identified. We want to make sure that they do have a voice here in these proceedings. Mr. Griffin argued that Mr. Murdaugh had been held accountable for essentially the same conduct, and luckily in the federal system, we have the benefit of relevant conduct, and so we don't have to have a count of conviction, so to speak, to hold a defendant accountable for the whole of their conduct. And so while Mr. Griffin argues that he's been held accountable, there are actually 11 victims who are not the subject of state convictions, and about $1.3 million in additional loss that's attributable to Mr. Murdaugh because of his theft of those victims, and we absolutely respect their desire to not be publicly identified and come here and address Your Honor and Mr. Murdaugh. We think that's further evidence of their vulnerability and their victimization, that they don't want to have to relive that before the court, but we think it's important that the court recognize these victims and the voice that they do have and the role that they do play.
Your sentencing memorandum laid those out in very helpful detail.
That's correct, Your Honor. And so in terms of the nature and circumstances of the offense, as I said, it really cannot be overstated when you look at the complexity of his scheme, the vulnerability of the victims, the abuse of the position of trust, the different ways that he was able to perpetuate and carry out his schemes by bringing in others to make sure that he was able to achieve his ultimate goal, all for his own enrichment. I'd like to address the history and characteristics of the defendant, but first if we can hear from some of the victims. Mr. Satterfield, Natasha Thomas, and Pamela Pinckney are all here today and wish to address the court, but I do want to recognize the other victims that are in the courtroom and ones who have submitted victim impact statements. Mr. Jacob Hirschberger is deceased, of course, but we had family members who submitted victim impact statements on his and their behalf. They could not be here today because they live out of state, but we just want to recognize that they have submitted impact statements for Your Honor. Mark Tinsley is here on behalf of Mr. Arthur Badger, who could not be here, and I know Your Honor wants to hear from the individual victims, but
Yes, I do. The format is for victims to speak, not attorneys. As much as I admire the attorneys that fought this fight, we're not going to hear from them today.
Okay. Mr. Jim May is here on behalf of the law firm, as well as a few of the partners from the law firm. Greg Harris is here on behalf of Palmetto State Bank, as well as Mr. Jim Malinowski. Eric Bland is here on behalf of Tony Satterfield, but also a few of the victims that couldn't be here. Miss Elena Plyler and Miss Hannah Plyler, and then of course Mr. Bamberg is here today on behalf of numerous other victims who are not intending to speak. If I can ask Mr. Tony Satterfield to address the court?
Please, if you could come forward. Good morning, Mr. Satterfield.
Good morning, Your Honor. Question, you mind if I face this way?
You're welcome to face any way you wish.
Okay. First, I want to say I'm sorry you feel like you had to do what you did to me, to my family, other victims. My heart goes out for you. My heart goes out for your family and everybody involved.
Thank you.
I pray for you daily. I know you know. This team wants one thing. This team wants another thing. What I truly want is you. I just want God to work on you and your heart, you know? And a lot of people probably say there is no hope, but there is. And it starts with the gospel. So yeah.
I know, Judge Gergel. You said you didn't want to hear from the attorneys. I don't. But I represent the victims that I know you do, and it's the Plyler sisters that are mainly part of the... I've heard from them, and I know their plight very well, and I remember them with great clarity. You don't need to speak for them. I've heard them before. Well, I'd like to thank Your Honor for your dogged pursuit with Russell Lafitte, with Corey Fleming, and now with Mr. Murdaugh. I'd also like to thank Emily and Winston and the FBI for their dedication to seeing that justice is done. So thank you, Your Honor. Thank you.
Miss Pamela Pinckney.
If you could state your name for the record, please.
Pamela Pinckney.
Good to see you again, Miss Pinckney.
Good morning, Your Honor. On behalf of Mr. Justin Bamberg, I thank and praise God for being here on this morning. And to Mr. Alex Murdaugh, there's nothing that I would ever say to humiliate or degrade you because only God can judge you for what you have done wrong. Like I told you, I love you with the love of Jesus Christ.
Thank you. I love you.
Anything further, Miss Pinckney?
That's it, Your Honor.
Thank you so much for being here. Thank you, Miss Pinckney.
And Your Honor, I'll just say hello, and this is Tyrone Pinckney. Natasha Thomas couldn't be here. This is her father.
Very good. Thank you for being here.
Your Honor, if I can move to the history and characteristics of the defendant, and I also want to address some of the allegations that Mr. Griffin made about federal interests here. Of course, we defer to our state partners in their prosecution of Mr. Murdaugh for the murders of his wife and son as the most severe conduct. We also intended to charge him for the federal financial crimes and hold him fully accountable, but really with the goal of providing a backstop that should anything fall through with those murder convictions, we would have charged him and held him accountable within our own statute of limitations, such that we wouldn't be prohibited from doing so in the future. But we also hold two distinct federal interests that we wanted to continue to pursue in holding him accountable for those financial crimes. And those federal interests were in mind in negotiating the plea agreement. And of course, we all agree that we are no longer bound by that plea agreement. But we had agreed to recommend a concurrent sentence, which is what the guidelines require.
I didn't think you were giving up much on that one, Miss Limehouse.
Well, he agreed to do it.
Yes. He wasn't exactly in the strong bargaining position.
Well, exactly. We have great evidence, of course, which helps. But our two federal interests were finding the $6 million plus in ill-gotten gains that remains unaccounted for today. We have a duty to pursue the location of those proceeds and attempt to make the victims whole. And so we intended to pursue every avenue to locate those funds through whatever means necessary. And then, of course, our second federal interest was holding all accountable who committed these crimes with Mr. Murdaugh. We knew that Russell Lafitte and Corey Fleming had conspired with him to help steal some of the client's monies, but we weren't sure if others were involved. And so those were our two federal interests in giving Mr. Murdaugh an opportunity to cooperate fully with the government. And so we entered into the plea agreement, which required him to cooperate fully, to provide information about all criminal activities about which we had knowledge. not just the charges that were charged in the indictment. Mr. Murdaugh proffered from the federal government and the FBI and SLED on a few occasions for specifically in 2023, May 4th, June 7th, August 18th, and October 18th. And during each of these proffer sessions, we gave Mr. Murdaugh every opportunity to come clean about others' involvements in his criminal schemes and the locations of those assets or those proceeds. We presented the financials to him that showed there were over $6 million in unaccounted for proceeds and gave him every opportunity to come clean about where any hidden assets or hidden funds could be. He remained adamant, as did his attorneys, that all of those funds were spent on drugs, and it didn't add up. It didn't add up because the financials didn't make sense. It didn't add up because he claims to have been using the same amount of drugs since 2008, but the laundering escalated by millions in the late 2019s, 2020s, and so it didn't make sense. And so at the time, we decided to polygraph him on those two federal interests because we didn't believe that he was being fully candid with us about the involvement of others or the location of hidden assets or funds that were ill-gotten gains. And so he was polygraphed on these 2 points of federal interest, and the polygraph indicated deception, and so he breached the plea agreement at that point. And so while we recognize that he has taken full accountability for his conduct in this scheme, in these schemes really, he has not assisted the government in what we believe is the potential involvement of others in his schemes or the location of assets that can really help to make the victims whole. He argues that these victims have been made whole by others and that he should somehow receive the benefit of those victims not being out of pocket any additional funds. But Alex Murdaugh has never spent a penny of his own money to make these victims whole or helped find assets that can do that. And so he shouldn't receive any benefits from the others having to come in and take the financial fall for his crimes. So we think that goes to the history and characteristics of Mr. Murdaugh. You're familiar with the breadth, the scope, the length of his schemes, but we don't believe that the drug abuse was the reason why he committed these schemes, and we don't believe that that's how he spent over $6 million. And so when given the opportunity to fully cooperate, he didn't do that. And we think the court should take that into consideration when fashioning a sentence that's sufficient but not greater than necessary. Finally, Your Honor, of course, under 3553A, we think that it's important that the court impose a sentence that reflects the seriousness of the offense, promotes respect for the law, provides just punishment, and protects the public from future crimes of the defendant. We believe that Mr. Murdaugh is incapable of being a law-abiding citizen. He lived this way for so long it became such second nature to him to deceive every single person in his life. But we don't believe he's capable of living a law-abiding life as an upstanding member of society. We are requesting that the court impose a sentence of 30 years, which represents the statutory max, and of course would be a variance to the current guideline range that Your Honor has set forth on the record. Under 3553A, Your Honor has already alluded to, this is really an unparalleled circumstance in South Carolina. We really haven't seen anything like Mr. Murdaugh in the state of South Carolina, and so while the guidelines might be for the usual defendant who's stolen this amount of money under these circumstances, we don't think he can be compared to other defendants in similar circumstances. And so, because Your Honor's not inclined to impose a consecutive sentence, we're recommending a concurrent sentence of 30 years, which is the statutory maximum.
Well, it's not actually the statutory max now, Miss Limehouse, is it?
That's true. You could stack absolutely. And we believe a 30-year sentence is sufficient, but not greater than necessary. He's 55 years old. I will correct one thing Mr. Griffin stated, that the BOP, of course it's up to the BOP, would give him credit for time served. Actually, by statute, under 18 U.S.C. 3585B, we don't believe he'll get any credit until today for any of the time he served on these financial crimes. As a 55-year-old man, 30 years is a death sentence, so to speak. And that's, of course, taking into account that he's already serving 2 consecutive life sentences for the murders of his wife and his son.
Well, you haven't addressed the issue of deterrence.
Sure.
And the issue of general deterrence. Talk to me about that.
Well, as you acknowledged, and we've all talked about, his violation of public trust. but specifically as it relates to a lawyer and someone who's given the opportunity to commit these crimes by nature of their law license, and what that has done to sort of the legal community and the reputation of the legal community, I think it's really important that the court send a very strong message about lawyers stealing money from their clients. Of course, we're talking about millions and millions here, but I think the general deterrent effect would apply to all lawyers who would seek to abuse their position of trust by taking advantage of the opportunity given to them in that position of trust to steal from their clients. I think that's very important.
Miss Limehouse, I speak to law students all over the United States, and I tell them that a law license is a license to do good.
Should be.
Should be. This is a demonstration of the darker side of the law license, because it affords those inclined to a criminal mindset to abuse their clients, to steal from their clients, and perhaps the most important part of this sentence might be to deter others so that licensed, or to be licensed, know of the grave consequences of such conduct. You know, if the state convictions for murder stand, the sentence is academic, but a verdict is to speak the truth. And the statement we make today, we make for the United States, we make it for the court, we make it for the interests of justice.
I couldn't agree more.
Anything further?
Nothing from the government, Your Honor. Thank you.
Mr. Griffin, anything in response?
Yes, Your Honor. Miss Limehouse just pointed out, under Title 18, that he will not get credit for...
Let me tell you something. I learned a long time ago, Mr. Griffin, that I don't try to guess what the Bureau of Prisons is going to do. They have as high regard for my opinion as they do yours, okay? And so I don't know what they're going to do and how they're going to interpret it, but that's not a factor for me to consider, because that's not a factor I can determine. It's a very complicated situation. I'm going to impose a sentence and the chips will fall where they may. Yes, Your Honor. The Bureau of Prisons will make that determination if and when that becomes something they need to do.
Yes, Your Honor. And just one brief point about deception and polygraph. We have in our sentencing memorandum the Department of Justice's policy that there is no lie detector. It's a polygraph machine that's used for an investigative technique, and that's it. And someone who has a reaction that scores on a polygraph machine, it's not evidence of a lie.
And Mr. Griffin, let me say something. As a lawyer, I was very familiar with polygraphs. I represented SLED from time to time. I knew the polygraph examiners at SLED very well. And as high regard as I held for them, and I'm sure the FBI polygraph examiners are just as capable, there's much mystery to what you detect when you detect what is called deception. Are you responding to the very question asked, or perhaps other facts in which the person being tested may feel guilty about? So I don't put any weight in a polygraph. We wouldn't admit it in my court. And you agreed with the government to allow your client to be polygraphed and to be dependent in some way on the results in terms of the plea agreement. That's your private deal. But I give no weight to a polygraph myself.
Thank you, Your Honor. That's all I have.
Yes, sir. Let me, if I might, first announce the sentence, and then I will explain on the record the 3553A factors, because I do intend to upwardly vary regarding this sentence. Having calculated and considered the advisory sentencing guidelines, and having also considered the relevant statutory sentencing factors contained in 18 United States Code 3553A, it is the judgment of the court that the defendant, Richard Alexander Murdaugh, is hereby committed to the custody of the Bureau of Prisons to be imprisoned for a term of 480 months, which consists of 360 months as to counts 1, 2, 3, and 4, said terms to run concurrently with each other in all other counts, and 240 months as to counts 5, 6, 7, and 8, said terms to run concurrently with each other in all other counts, and 120 months as to counts 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, and 22, said terms to run concurrently with each other and consecutive to all other counts. These terms shall run concurrently to the remainder of the undischarged state terms of imprisonment for the South Carolina General Sessions Court, dockets numbers referenced in paragraph 189 of the pre-sentence report, which is considered relevant conduct to the incident offenses of conviction, pursuant to Sentencing Guideline 5G1.3b2. Furthermore, these terms shall run concurrently to the prior undischarged state term of imprisonment for the South Carolina General Sessions Court, docket numbers referenced in paragraph 190 of the pre-sentence report, which were not considered relevant conduct to the instant offenses of conviction, pursuant to Sentencing Guideline 531.3d. It is further ordered that the defendant shall pay mandatory restitution in the amount of $8,762,731.88 to the victims in this case through the Clerk of the United States District Court, 85 Broad Street, Charleston, South Carolina, $102,221.90 is ordered jointly and severally with co-defendant Corey Fleming under docket number 9, 23-CR-394, and $1,414,826.53 is ordered jointly and severally with the co-defendant Russell Lafitte under docket number 9, 22-CR-658. Payments are due and payable immediately, as the defendant has no income and has been ordered to pay a substantial amount of restitution. Interest on restitution is waived, as defendant lacks the apparent ability to pay interest. It appears the defendant does not have ability to pay a fine, therefore the fine is waived. The defendant shall pay the mandatory $2,200 special assessment fees, which are due and payable immediately. Upon release from imprisonment, the defendant shall be placed on a term of supervised release for a term of 5 years, consisting of 5 years as to counts 1 through 4 and 8, and 3 years as to counts 5, 7, 6, 7, and 9 through 22, said terms to run concurrently. While on supervised release, the defendant shall comply with the mandatory conditions of supervision outlined in 18 United States Code 3583D and Sentencing Guideline 5D1.3A, and the standard discretionary conditions outlined in Sentencing Guideline 5D1.3C, as noted in paragraphs 193 and 196 of the pre-sentence report. Standard conditions of supervision 1 through 9 and 13 serve the statutory sentencing purposes of public protection and rehabilitation pursuant to 18 United States Code 3553A, 2, C, and D. Standard conditions of supervisions 10 and 12 serve the statutory sentencing purpose of public protection pursuant to 18 United States Code 3553A2C. Standard condition of supervision 11 ensures that the defendant does not engage in activities that may conflict with other conditions of supervision that may pose risk to the defendant's probation officer. The defendant shall also comply with the following special conditions for the reasons set forth in the pre-sentence report, which has previously been adopted by the court as findings of fact for purposes of sentencing, and if I did not expressly state, I'll say it now, that the court adopts this pre-sentence report as the findings of fact for purposes of sentencing. Number 1, you must not incur new credit charges or additional lines of credit without the approval of the probation officer. This condition is ordered, based upon the nature of the offense, to deter and detect potential future economic crimes, to assist the defendant in gaining control of his financial situation, and to serve the statutory sentencing purposes of public protection, deterrence, and rehabilitation. Number 2, you must provide the probation officer with access to any requested financial information and authorize the release of any financial information. The probation office may share financial information with the United States Attorney's Office. This condition is ordered based upon the nature of the offense to deter and detect potential future economic crimes, to assist the defendant in gaining control of his financial situation, and to serve the statutory sentencing purposes of public protection, deterrence, and rehabilitation. Number 3, you must pay any remaining unpaid restitution and balance imposed by the court in minimum monthly installments of $250 to commence 30 days after release from custody or following the imposition of sentence if, after release from custody, payment shall be adjusted accordingly based upon your ability to pay as determined by the court. This condition is ordered because restitution is mandatory in this case. And finally, you must submit to substance abuse testing to determine if you used a prohibited substance. You must contribute to the cost of such program not to exceed the amount determined reasonable by the court-approved U.S. Probation Office sliding scale for services, and you will cooperate in securing any applicable third-party payments, such as insurance or Medicaid. This condition is ordered based on the defendant's admitted substance abuse history to deter and detect future illicit drug use, to assist the defendant in gaining sobriety, and to serve the statutory sentencing purposes of public protection, deterrence, and rehabilitation. Now, I have imposed a sentence which this court believes sufficient but not greater than necessary to accomplish the purposes of the law. In doing that, I have considered all of the factors under 18 United States Code 3553A to impose a sentence which is sufficient but not greater than necessary to accomplish the purposes of the law. Let me address the ones that I consider most relevant to our situation here today regarding this case. I considered the nature and circumstances of the offenses. Criminal conduct was taken over 15 years, detailed in paragraph 106 of the pre-sentence report. It involved thefts from a total of 27 clients of $9,400,000 and $1,400,000 from his law firm, with a total of nearly $11 million. The list of thefts include a remarkable combination of extremely vulnerable victims: a paraplegic, motherless children, a grieving widower. Access to these funds was obtained through a position of trust as an attorney for people who put their faith in the defendant. This was reprehensible conduct. It deserves significant sanctions. I've considered the history and characteristics of the defendant, which really is traced through since 2005, the systemic theft from clients. I've considered these offenses very serious, each offense. I believe this sentence promotes respect for the law and provides just punishment. The defendant's conduct has brought disgrace and disrepute to himself, his law firm, the Hampton County Bar, the South Carolina Bar, and the South Carolina court system, if not the American court system. A serious sentence is necessary to uphold respect for the law and to make clear that the defendant is held accountable for his disregard for the rights of his clients and rampant, uncontrolled dishonesty. There also must be justice for his victims, who suffer anguish on top of the tragedies that have brought him to his office, or were brought to his office from his assistants. I mentioned earlier to Ms. Limehouse the question about deterrence. It is important, critical in this case, to provide deterrence for further crimes, not just of this defendant, which I agree, based on his past. If he were to be released, I think he would continue to engage in criminal activity. But most important, the general deterrence here, that is, to deter others, particularly lawyers and other fiduciaries. There's little doubt that, of all people who might be deterred, lawyers might be deterred the most from the consequences of dishonest conduct. And this sentence is intended to demonstrate the serious consequences to attorneys and other fiduciaries who engage in such conduct. Another element of 3553A is to avoid unwarranted disparities. Mr. Griffin correctly pointed out in his filing about the medium range in such cases and the average range, 168 months, average for wire fraud, 210 months, a medium for someone of this offense level. But this is not the normal case. I've been on the bench 14 years. I practiced law for over 30 years. I've never seen this type of conduct, a massive fraud over many years which took a human toll on its victims. You know, I was reading recently a sentence imposed by a colleague of mine, Denny Chin, in the southern of New York. He said of a case of massive white-collar crime, he says, "Objectively speaking, the fraud was staggering. The breach of trust was massive. The crimes were extraordinarily evil. Not nearly a bloodless crime that takes place on paper, but one that takes a staggering human toll. No other white-collar case is comparable in terms of scope, duration, and the enormity of the fraud and the degree of betrayal." That was in the sentence of United States versus Bernard L. Madoff. I think that is the more analogous situation here of a methodical financial crime, devastating his victims over a prolonged period of time. Judge Chin actually imposed a 150-year sentence. Perhaps I showed restraint. But the point is made that this sentence must speak the truth. And the truth here is that this is a reprehensible crime that deserves the most serious sanction. Let me provide Mr. Murdaugh his appeal notice. You can appeal your conviction if you believe your guilty plea was somehow unlawful or involuntary, or if there was some other fundamental defect in the proceedings not waived by your guilty plea. You also have the right to appeal your sentence under certain circumstances, particularly if you believe this sentence is contrary to the law and, again, not waived by your guilty plea. You must file an appeal within 14 days from the entry of judgment. Further, you have a right to apply to appeal in forma pauperis, and the clerk of court will prepare a notice of appeal upon your request. From the defense, are there any other matters to come before the court?
No, Your Honor.
From the government?
We'd ask that you incorporate the government's final order of forfeiture into the J&C. The total for forfeiture is $10,034,377.95.
That motion is granted. Anything further, Ms. Limehouse?
Nothing further, Your Honor. Thank you.
This hearing is adjourned.